Please be seated. We'll hear argument in 21-232, Monroe Guaranty Insurance Company versus Bitco General Insurance Corporation from the Fifth Circuit. We'll hear from the appellant.
May it please the court, Mr. Krosno will present argument for the appellant. Appellant has reserved 5 minutes for rebuttal.
May it please the court. It's good to be back in any courtroom, and especially this courtroom, and especially since this is the point of a Zoom presentation when I would normally be figuring out that I'm still on mute and nobody can hear me. So good to be here. There are two certified questions before the court today. The first of those is whether to recognize the exception to the 8 corners rule articulated by the Fifth Circuit in the Northfield Insurance versus Loving Home Care case. This narrow exception permits consideration of extrinsic evidence on the duty to defend when it is initially impossible to determine from the underlying complaint whether a covered claim is alleged, when the evidence goes solely to fundamental coverage issues, and when it does not overlap with the underlying merits or engage the truth or falsity of the complaint allegations. The court should answer yes to this certified question for 3 main reasons, which I'll first summarize and then address in more detail as time permits. Those reasons are that first, the Northfield exception is consistent with the policy language. Second, the exception is necessary to fill in the factual gaps caused by modern notice pleadings and artful pleadings, and to thereby prevent unjust results for both insurers and insureds alike. And third, the exception, or at least a similar exception, has been recognized for decades by lower Texas courts and by the Fifth Circuit, and the sky has not fallen in the meanwhile. Now, turning to the contract rationale in a bit more detail, this court recognized in the Richards versus State Farm case that the duty to defend is a creature of contract, and that the goal in interpreting that duty is to determine the party's intent as expressed in the contract. Monroe's policy, like most CGL policies, states that Monroe has a duty to defend the insured against suit seeking covered damages for bodily injury or property damage, but has no duty to defend a suit to which the insurance does not apply. Nothing in this language requires an insurer to defend a suit when it is impossible to tell from the complaint whether a covered claim is alleged, much less when undisputed evidence proves the claim is not in fact covered.
And in this case, it's agreed as to what the dates of coverage were for each insurance company, correct?
Yes, that's correct.
And the date of the occurrence.
Yes, the date that the drill bit stuck in the borehole is a stipulated fact.
So are you asking for a rule that would be limited to these uncontested type matters?
Well, Your Honor, the case law, including the Northfield exception, don't limit extrinsic evidence to undisputed evidence if the other requirements of the exception are met.
But the restatement does. So what's your view on whether that's proper?
The restatement does, and it's a little bit different than what's in the Texas cases and the Fifth Circuit cases. What I would say is that as a practical matter, usually this sort of evidence will be undisputed or agreed to by the parties because it's very difficult to fire up a declaratory judgment action, then do discovery, and then get a ruling on a disputed fact issue. So typically it will be as it was in this case.
In the prior, I'm sorry, go ahead. I was just going to say, in the prior case, they argued that it's always going, just the opposite of that it will always be contested, right?
Well, if you look at these cases, in quite a few of them, there is some sort of stipulation or at least some sort of undisputed documentary evidence that the insurer and sometimes the insured is relying on. So I don't think it should be limited to undisputed evidence as the restatement does. If, for instance, a policyholder wants to deny that the sun sets in the west and require some sort of discovery on it, I don't think the insurer should be precluded from doing that. But at the same time, as a practical matter, it's not going to happen very often. Now,
Assert that there's coverage in the face of the stipulated fact here about when the drill bit stuck. Wouldn't an insured have to present evidence in the deck action about the duty to defend that, look, there was some property damage that occurred during the policy period? And isn't that against the insured's interest in the underlying suit, where they want to take the position that, the casing was fine, there was no underlying seepage? Aren't you putting the insured to a pretty difficult position where they have to sort of admit liability to obtain their defense?
Well, here it was a stipulation, so it wasn't disputed, and we also.
But when the drill bit stuck wasn't disputed, but could you refute evidence about when the drill bit stuck as being the determining date about whether coverage is owed because additional property damage occurred during the policy period at some later date?
Well, here, Your Honor, there wasn't a dispute about it because among other reasons, the underlying lawsuit had already settled, so there wasn't any danger of prejudice to the insured. And this rule is crafted to avoid that danger of prejudice to the insured by saying that you can't use extrinsic evidence that overlaps with the underlying merits or that engages the truth or falsity of the underlying complaint allegation. So I don't think that danger of prejudice is present under the Northfield exception as stated.
So does that mean the exception wouldn't apply here because the insured would have to prove when the damage occurred that they deny occurred?
Well, Your Honor, here there was a stipulation about when it occurred, and that stipulation is something that was not alleged in the underlying pleadings, and there's no evidence that it was ever in dispute in the underlying case at all in terms of the timing of when it had occurred. So I don't think this is a situation where that particular requirement is not met, and they haven't been able to demonstrate that it's not met.
Is this also a case where Northfield might not apply because it's initially impossible? It is possible to discern whether coverage is potentially implicated from the from the pleadings as they're alleged here?
Well, I don't think it is possible to discern, and the federal magistrate judge who looked at this agreed with this, that it was not possible. There are no dates alleged concerning when the property damage occurred.
But it just has to be potentially implicated, right? And there are dates after that. There are things that happened according to the complaint, I guess, since this is from federal court, like failing and refusing to plug the well and failing to case the well, allowing the clay to slough off, which presumably happened after the drill bit got stuck.
Well, the drill bit under the stipulation is and in the petition itself is what rendered the drill bit or rendered the well practically useless for its intended purpose, and also damaged the aquifer and the free flow of water in it. So I don't think this is a situation where the court can say there is potential for coverage just because the petition doesn't affirmatively rule it out, and I don't think the court's cases have ever gone that far. I do recognize
that word potentially is creating a lot of the disagreement here.
Right.
Because you can look at the word potentially in this context and think, well, if the insurance company can't conclusively demonstrate the absence of coverage, then there's always potentially coverage. If that's how it works, though, then the Northfield exception isn't an exception, and the Fifth Circuit shouldn't have been looking at extrinsic evidence in most of the cases where it has. So what do we do with that word potentially? What does that mean? Should we get away from it? And
I agreed on that, but there's a tension here, and let's discuss about what it is. There's a tension in the court's case law because the court has said you look at the potential for coverage in cases of doubt, you resolve it in favor of the duty to defend, and you've said that in cases such as Hayden and Dallas Fire versus King. But you've also said in other cases, such as Merchants Fast Motor Lines and I believe the Pine Oak Builders case, that you don't read facts into pleadings and you don't imagine factual scenarios that might trigger coverage. So there's a tension there, and the Northfield exception is a reasonable and contractually sound solution to that tension or to that problem.
But my question is, if we adopt the Northfield exception, what do we say that word potentially means, and what is it doing in that formulation of the rule?
Well, I've always thought that it means if there's doubt, for instance, about whether conduct alleged is an occurrence, is whether it's accidental or really whether it's more intentional, or whether there's doubt about whether property damage is actual property damage versus economic loss, then that would be a situation where that potential language might come in. But in this situation, there is no allegation about whether the property damage occurred. The other factor you really have to look at here is that it's the insured's burden of proof to prove that a claim falls within the insuring agreement, and our insuring agreement requires property damage within the policy period. So I don't think you can adopt a rule that just says because the petition doesn't affirmatively show the absence of coverage that you're always going to have a duty to defend. Again, the Northfield exception is a good solution to the problem. It doesn't require an insurance company to defend non-covered claims, and it also doesn't run afoul of the case law and the language in some policies saying you have an insurer has a duty to defend groundless, false, or fraudulent claims.
To put this in context, just as a general question, I want to make sure I'm understanding this correctly. If a insurer accepts the duty to defend under reservation and provides a defense, but then goes and files a DJ action, or the discovery ends up proving that there's no coverage, is there ever a scenario where that insurer can recover the expense that they made on the duty, providing the defense under reservation?
I think that question was decided in, I believe, Frank's casing in Matagorda County, which, as I recall, the holding was unless there's an express provision in the policy requiring or permitting reimbursement, or unless there's essentially an agreement between insurer and insured, then there's no right of reimbursement.
Right.
I
So,
believe was the
like
wording.
here, for example, the two insurance companies could have come to an agreement and said, look, you provide the defense and then we'll end up paying you back if it turns out there was, so by agreement you can do it, but absent an agreement by law, there's no chance to recover defense costs paid under a reservation.
That's right, except under the...
I just wanted to make sure I had that, I understood that correctly.
Except under the circumstances discussed in Frank's casing.
By the same token, is there some ability for an insured to seek reimbursement for the costs, the litigation costs it will undertake in defending against the insurer's DEC action, seeking a declaration that it has no duty to defend?
Well, under the Texas Declaratory Judgment Act, there is an ability for the court to award fees as are equitable and just. So I think the answer, at least in Texas, to that question is yes. There's also...
There's no contractual right of reimbursement. If ultimately it's determined, yes, you owe a defense, you litigated it, the insured spent a lot of money, the insured's out of luck on that unless the judge decides to award it.
Under the Declaratory Judgment Act, or finds that there's a breach of contract under which you would be able to get
Chapter
attorney's
38.
fees.
Okay.
Now, the Northfield exception is also necessary, as we've argued in our briefing, to fill in the gaps caused by notice pleadings and artful pleadings. And it's a fact that under modern notice pleadings, oftentimes facts needed to determine coverage are not alleged in the petition and may not even be relevant to the underlying case. And sometimes savvy plaintiffs' attorneys will know how to leave things out of petitions in order to, that might negate coverage, or as here, omit dates that might limit the universe of potential coverage. And the Northfield exception addresses this problem by allowing extrinsic evidence to fill in the gaps in such petitions. And it also prevents manifestly unjust results that can arise from strict application of the eight corners rule. We gave examples in our brief. We haven't heard a response yet from the other side about why those unjust results wouldn't occur under their rule.
Any other questions? Thank you, Mr. Crosno. We'll hear from the appellee.
May it please the court, Mr. Farmer will present argument for the appellee.
Good morning. May it please the court. I want to start by saying I've been representing insurance companies in Texas now for 30 years. So I feel like I'm arguing against my own pecuniary interest here to some extent. But I think this is an important issue. My client thinks it's an important issue, and that's why we've taken this side of it. I've heard some excellent questions today that I ask myself at times when I'm dealing with these issues on a regular basis. The Northfield exception, should the court adopt the Northfield exception? And we think the answer here is emphatically no. I'm not suggesting that there may not be some circumstances where extrinsic evidence may be warranted in duty to defend cases. But the Northfield exception is not a workable exception. And some of the questions that were posed earlier about whether pleadings, it's initially impossible to discern from the pleadings if there is a duty to defend. How do you line that up with the fact that, well, if it's questionable, then you owe a defense? So we're sort of looking at ideas that are in opposite to one another. The second question that was posed by the Fifth Circuit to this court, to me, actually underscores the problems with the Northfield exception. The first thing the court says is the Fifth Circuit asked this court to look at was, when applying such an exception, may a court consider extrinsic evidence of the date of an occurrence? Well, the date of the occurrence is not even relevant. It's the date the property damage occurred. The active negligence has no bearing under well-established law from this court as to what triggers coverage for property damage. It's an allegation of when the property damage occurred, not when the causative negligence that precipitated that occurred.
So even if that rule is not something that the court wants to adopt, and certainly I have no idea if it is or not, but if, why would not it make sense to have some rule, particularly in a case like this, where the facts are undisputed, or you're saying they're not undisputed, but let's say in other cases where they are undisputed?
Well, I do believe there may be a legitimate basis for an exception where the insured and the insurance company do not dispute certain facts. I would be hard to argue that if the two parties agree on these items or issues, why should the court not be able to consider it? But in this case, we stipulated the date the drill bit got stuck. We didn't stipulate as to when any property damage occurred. That's a fact question for the jury. That's also an issue that's relevant to the liability issues in the underlying case. So in no event should the court answer yes to the second question here, even if it is inclined to answer yes to the first.
Does the property damage necessarily occur only on one date? What happens if it overlaps policy period?
And that can happen, and certainly does happen, and that creates a whole other litany of questions that I'm happy to address. Most policies include a provision that says what we call the Deemer clause. And that means that property damage that is a continuation, change, or resumption of the initial damage is deemed to occur on that first date. So it would all fall on the first property. That also raises other fact questions, though, as to whether subsequent damage is a continuation or change or resumption of initial damage, or is it new and different damage? Those are not questions that you can typically answer from the bench. They have to be addressed by a jury, typically. There may be some exceptions to that. Again, I would say if the parties are stipulating or agreeing as to when the damage occurred, that may be a different scenario. But a stipulation as to when an event occurred or the occurrence happened is not a stipulation as to when property damage occurred, and that's the triggering event for coverage under Texas law for property damage claims in duty to defend situations and in duty to indemnify. So to answer your question, that could fall under one policy under the Deemer clause, or it could be in multiple policies if the damages do not all relate to the initial damage. And as also been pointed out today, the drill bit getting stuck was one item of negligence that allegedly, that actually occurred. We stipulated that occurred. There are other allegations of negligence to other items with problems with the casing of the well and various other things that otherwise cause or allegedly cause some of the ultimate property damage that the plaintiff in our case complained about, and the underlying case complained about.
You say there should be some kind of exception, just not Northfield. So
Correct.
What should it be?
Well, I'm going to hearken back to what Northfield was reportedly based upon. Originally, the Bowl and Cook cases. Those cases make sense to me as to why you would look at extrinsic evidence. Both of those cases involved automobile accidents with excluded drivers. The policy had provisions, endorsements that specifically excluded certain drivers. The petition was silent as to who was actually operating the vehicle, or said it was the son of the insured without being more specific. In that case, the insured had one son, and they said, well, we're going to look at the policy. This person is excluded. And I think I don't know if this is the best way to refer to these or not, but I think some of the case law, Bowl and Cook, they talk about the fundamentals of insurance coverage, whether a person is insured, whether property is insured, or whether a policy exists. And of course, as this court has already addressed, fraud is also a possible exception. Beyond those items or a stipulation between the parties, I do not believe there should be any other consideration of extrinsic evidence in duty to defend cases. It will only serve to create additional ancillary litigation, as Mr. Campbell pointed out earlier. It's more efficient, more understandable for the policyholders and for the insurers if we follow I don't want to say a bright line 8 corners rule, because I think we articulated a few exceptions that I think would be okay or acceptable, reasonable, but one that is not.
Would this result in artful pleading?
I think it will, and I think we already have that. I think that's one of the issues we face all the time now. But an insurance company can rectify that very easily by creating a policy-created exception to the 8 corners rule, a contractual agreement between the policyholder and the insurance company that if you get sued and the pleadings are vague, we are going to look at extrinsic evidence, because otherwise, basically, you're punishing the insured for the behavior or pleading that's out of their control. They're opposed to that party. So you're going to base the idea that we're going to eliminate coverage for a policyholder of ours because a plaintiff's attorney who has sued that policyholder is not leading the case in a way that would either trigger or eliminate the duty to defend when it could.
And special exceptions don't provide a remedy for that problem?
That's a difficult question also, because a lot of times the defense attorneys that get retained, obviously by the insurance companies to represent the policyholders, don't want to file special exceptions because they don't want to plead their client outside of coverage.
Right.
So there may be circumstances where that would be possible.
The defendant here could have specially accepted and said, even under fair notice, we're not getting fair notice because we're not able to determine from the pleading whether we have coverage for this, so make them replead. The problem with that is, and the insurance company who's controlling the defense, at least theoretically, could require the lawyer to do that. Now, there's the three-point relationship there, but there'd be a kind of a breach on the part of the lawyer to do that, to file special exceptions that are going to result in their client not being covered.
Correct. So I think that's the problem you run into in that circumstance. And even with the tripartite relationship we have, under Tilly, as defense lawyers, when we represent policyholders, our obligation is still 100% to those policyholders. And I think in that circumstance, it would be derelict of your duty to file a special exception that you know is going to eliminate coverage or defense for your client. That's a tricky situation because the obligation that the attorney has to the policyholder, but the relationship the attorney likely has with the insurance company.
And then, so why doesn't a separate declaratory judgment action provide the remedy?
Well, in the same thing, in the DEC action, now you're looking at contradicting or potentially contradicting what is included in the pleadings in the underlying case. I guess arguably you're actually asking for clarification, more broader, more specific pleadings rather than what exists in the current pleadings. But under what we already have in Texas for fair notice pleadings, I don't know how you can justify or rectify those two things together, even if you do it in a separate declaratory judgment action, because now you're still going to have to look at what can we look at outside of the pleadings in order to determine the duty of defense. And is it appropriate for us now to file this DEC action to bring in additional information that you can't or that wasn't pled in the underlying case? The history of the Northfield exception is so shaky. I don't even like to call it the Northfield exception. It was articulated Northfield. They didn't apply it. It was based upon Wade. They didn't apply it. So we're talking here today about an exception that was created by two courts, essentially, neither of which even applied it in the cases that they created it. They determined it wasn't even necessary. So we're talking about an exception that is built on dicta that was built on dicta. The courts did not even apply these exceptions in the cases that they were created in.
Has any other state found an approach that you think works well?
Again, I feel like that, in my opinion, the best approach is to look at the fundamentals. Is the party insured? Is the property insured? Does a policy exist? Or has there been fraud? I think for anything else, a policy-created exception would be required in order to follow this court's precedent.
To your knowledge, has any other state adopted that approach, the fundamentals approach?
I don't know.
Yeah.
I can't say the answer to that. I'm sorry.
That's pretty close to what the restatement does, isn't
It's
it?
very close to the restatement. And it's also close to what Bowl and Cook did and what they talked about. It was only Wade that then said, oh, we're going to extrapolate on this and expand this even further. And then you have the Fifth Circuit basically saying we have one line of cases that establishes this rule. And that's just not true. It's completely inaccurate. And the 14th District recognized this in the Weingarten case and said, there's not one line of cases here, there's two lines of cases, and they really aren't even related to one another. So how these came to be conflated into one line of cases is still perplexing to me. And it's also a bit surprising that this hasn't been really raised before Weingarten, and no one's really brought this up very often. Because to me, it's pretty clear that Wade, which was 25 years after Bowl and Cook, decided that we don't really need to address this question, but we're going to talk about it. And I say we, it wasn't we, it was a lone judge who wrote that opinion. There was concurring opinions, but not as only to the extent of the holding that was required by the court. All of the Northfield, what was later called the Northfield exception information, was completely dicta and disagreed with by the other judges in that court and by multiple other appellate courts since then. The problems with Wade are well documented in the case law in Texas, in the intermediate appellate courts, and in my crystal ball, I've seen what this court has done and what I would think they would look at here and say that while there may be an exception to the Eight Corners rule that is warranted, this is not the exception. It is not fair to policyholders to require them to be beholden to a plaintiff's pleadings that are then going to be subject to extrapolation or additions by their own insurer just as a way to negate coverage for the policyholder.
Well, but isn't the thinking behind that, though, that the insurance company has agreed to defend covered claims? It has not agreed to defend claims that aren't covered. So we're trying to hold them to that bargain.
I'm glad you asked me that question, because that language, appears in almost all CGL policies, as Mr. Krosno pointed out. But if you take that language to its nth degree, what you're basically saying is you don't owe a duty to defend if the claim's not covered. And we know that's not true. We know the Eight Corners rule exists.
Well, what we said in Richards is that you look to whether the claim is covered, so that the claim is what's stated in the petition, and you determine whether that is covered.
Or potentially
at
covered.
the initial stage. Well, that word potentially causes a lot of confusion here, I think. But you look at whether the claim is covered by looking at the petition, which states the claim. But if you just put blinders on and refuse to, if you have evidence staring you in the face that demonstrates whether or not the claim is covered, and you just ignore it, why aren't you holding the insurance company to a deal it didn't make, requiring it to defend a claim that is demonstrably not covered?
Well, that's what I'm saying, we already do that. Because of the Eight Corners rule, carriers defend claims that ultimately are not covered or for which they have no duty to indemnify all the time. And that's
Well, depending on how the facts develop and what ends up being determined true and false through the litigation process, it may end up that the claim wasn't covered. But if we know up front, I'm struggling with how this interacts with, if what we're doing here is holding the insurer to its bargain, and we're just ignoring evidence that conclusively demonstrates whether the insurer has agreed to defend claims like this, I'm struggling with whether we're really doing a contract-based exercise there, or are we just sort of applying a judicially created notion of fairness to the insured and that sort of thing.
I think I understand what you're asking. I believe that's why if there are circumstances where there are undisputed facts, I'm going to say that, let me say that a different way. If there are stipulations between the parties as to certain facts that bear on coverage that are not referenced in the pleading, when I say the parties, the insured and the policyholder, if they are able to stipulate to certain facts that take the claim outside of coverage, I see no reason why those facts cannot be considered. If they're both agreeable to stipulating to that, then that's an issue that's between the two of them. They're the parties to the contract. And if they're willing to stipulate to certain facts, and I'm assuming these facts are going to be the types of facts that you're talking about here, not necessarily when property damage occurred, but whether someone is insured, whether someone was actually operating an automobile or not operating an automobile. That may be, I have a case like that going on right now where there's an allegation that the owner was operating it, but someone else was actually operating it.
Of course, the problem with only considering stipulations is that if one side knows what's at stake, they'll never stipulate, even if the evidence is conclusive.
And that's potentially true as well.
So.
And of course, there's not an easy answer to this question. Obviously, that's why we've been dealing with this for 50 years without confronting it probably more head-on as to what the exception, if anything, it should be. Because I spent a lot of time, because I was prepared that I would be asked, what type of section would you suggest if you're not suggesting this one? And it's very difficult, because every time I would try to come up with something, then I would think, well, then it might not work in this scenario or this scenario. But fraud, of course, we have, as the court's already determined, is a legitimate exception. Beyond that, I just find it incredibly difficult to reconcile all of this court's rulings regarding favoring the insured, liberally construing the pleadings, et cetera, with an idea that we're now going to bring in outside evidence to say, no, never mind. We're not going to liberally construe these pleadings any longer like this. We're just going to say, we're going to bring in extrinsic evidence to say, well, you don't know a duty to defend because the policy says that you only owe coverage for claims that are covered by the policy. Again, that is something that if the insurance industry or individual companies want to address, they certainly can by making the appropriate changes to their policy language that allow them to consider that evidence. But otherwise, I think for the insureds to get the benefit of their bargain, that they need to be provided a defense in circumstances where the pleadings themselves do not bring the claim outside of coverage. I think another problem in Northfield is, it doesn't really take into account the fact that Wade was basically an island unto itself and not respected or accepted by Texas courts. I'm sorry, my time is up.
Any other questions? Thank you, Mr. Farmer.
Thank you.
Mr. Krosno, I believe you have 5 minutes.
Thank you. First, I want to address the criticism that Northfield is not a workable exception and it's based on dicta. The origins of the Northfield exception are in Ball and Cook, which date back to 1965 and to 1967. Were not dicta and are still being followed both in the Fifth Circuit and in Texas courts. Those dates I noticed as I was getting ready, 1965 and 1967 bracket the year that I was born. So, and though I hate to admit it on the record, I'm not a spring chicken anymore, and those cases aren't either. They've been around a long time. They've been working a long time. The other side has not identified any major problems with that courts have had in applying those cases. The major issue has always been whether this court was going to recognize the exception or not, and it should do so now. Northfield, it's true, in the course of articulating the exception, made the eerie guess that this court would not recognize it, but then went ahead and addressed that issue as part of an alternate holding. In subsequent decisions, the court has recognized, the Fifth Circuit has said that we're following the Northfield exception. We're making the eerie guess that this court would follow it. Wade is, again, a case that goes back to Ball and Cook, which are not dicta. So I don't think you can dismiss these exceptions as dicta, especially when we still have courts following them today. They are workable solutions. Now, the question to my opponent was, what should the exception be, since you seem to be acknowledging some sort of exception? And he says one that would allow for fundamental coverage issues. Well, the Northfield exception does say fundamental coverage issues, so that's not really different than what he's saying. I think what his argument is that fundamental coverage issues should be limited to those coverage issues identified in some of the cases, such as whether a person is an insured under a policy, whether property is covered under a policy, and whether a policy exists. But the list in those cases were illustrative. They were not intended to be exhaustive, and to the extent they were intended to be exhaustive, they're incomplete. Our brief went through various examples of where you could end up with a claim under a professional liability policy where demands made during the one policy period, a written demand, and then the suit is filed in the second policy period, and if you just do a strict application of the eight corners rule, the second insurer would have the duty to defend, even though they would never have a duty to indemnify. And so you're going to end up with manifestly unjust results and ones that don't recognize that whether a policy's insuring agreement is triggered in the first instance is a fundamental coverage issue. And
That's kind of the problem, though, with recognizing any exception is you got to draw the line somewhere or there's no line at all, and there's no clear logical place to draw the line.
Well, and if I were drawing up this rule, I wouldn't impose a fundamental coverage issue limitation because it just does lead to a lot of questions about whether it's fundamental or a specific issue is fundamental or whether it's not. It is in the Fifth Circuit's.
Which is why it seems to me we really, like we said in Richards, need to come back to the contract, because that's the basis of this duty. How is considering extrinsic evidence for the duty to defend consistent with the contract language?
Well, the contract language certainly doesn't say you can't consider it, and it does limit the duty to defend to covered claims. And so you end up in this situation. I don't disagree about the potential for coverage being a relevant standard, except for it doesn't answer the question of what happens when you can't determine from the policy whether there's coverage or not, because it omits a fact that's relevant to coverage. And that's why you do need to recognize this exception.
Thank you, Mr. Crosno. Any other questions? Thank you. The case is submitted, and the court will take another brief recess.
All rise.